3, 2, 1.
All right, good afternoon, commissioners. I'm going to call the meeting to order, and I'll call the roll. And I'm doing that this one and only time because we don't have a chair. From here on, you will have a chair, and the chair will run your meetings, and I'll just be here to watch. I'm going to call the roll. Jim Martin.
Here.
Vonna Wilson.
Here.
Jerry Sharber.
Here.
Juanita Patton.
Here.
Okay, and that's everyone that's on the board is here. We have minutes that are part of your packet. I think they were made part of your packet. Has everyone been able to look at those? And would you like to make a motion to approve them? We can also defer them if you want.
I make a motion to be approved.
Okay.
I'll second.
Any comments, suggestions, changes?
Shauna, what packet are you talking about? I have the notebook that you gave me, but I'm not sure what I should have in addition to that.
Okay, well, you probably, so everything that we do is online, and I'm not sure if maybe we didn't share that with you. Everything is through the Civic Clerk website. So if you're not ready, we can defer the minutes, and we can push them to the next meeting if you want.
Same.
Whatever.
I think.
No, you'll have
yeah.
to sign me up for that website because I'm not registered.
Okay, we can get you attached to that. Do you want to defer it?
Yeah, be fine.
All right, so would you also, okay?
Yes.
All in favor of deferral to the next meeting?
Aye.
All right, so now I'm going to turn it over to you. You, I think, are ready now to have your chair and your vice chair. You'll need nominations on the floor for a chair, and then we'll vote on that, and then nominations for a vice chair, and we'll vote on that. And at that point, I will turn the meeting over to the chair.
I'll nominate Jim Martin to be our chair.
Are there any? Oh, yeah, make sure you hit your button. And then
I
maybe,
didn't do that. I'll do it again. I nominate Jim Martin to be the chair of our commission.
are there any other nominations? Okay. All in favor of Jim Martin being chair of the Ethics Commission, say aye.
Aye.
Any opposed? Okay. Jim, you are the chair.
Very well.
Do you want to take it over for the vice chair?
I'm happy to do that.
Okay. Is your mic on?
No, it's not. I'm happy to serve, and I will do that. I do have some questions. We have consideration and approval of the bylaws and procedures, and is that part of a packet that I should have as well?
That I emailed to you, and I also, it was also part of the packet. I do have copies. Can we get copies made?
I have an extra copy if you need.
So I have the notebook, okay?
This wasn't part of the notebook. It was the bylaws that I drafted, and I think I sent them out to you guys by email about a week ago.
I have not seen them. I apologize. Do you know
That's
what address you used for my email?
I might have used both, but I'm not sure.
Okay,
I'm not sure. We can get a copy for you really quick.
all right.
Anyone else need a copy?
I do.
Okay, 2 copies. All right.
Can you then summarize for us the procedure for the commission? Because what I'm used to doing is running a court, of course.
That's true.
And I hear evidence from both sides. I rule on evidentiary questions, rule on the outcome. How will the commission differ from how you would hear a judicial proceeding?
And that's,
I think that's covered. Will be covered.
yeah, that is part of what we'll
Did you
talk
get
about
it?
in number 3.
Okay.
In the bylaws. So the bylaws cover 2 different ways that you have meetings. One is the normal, the chair opens the meeting, you follow Robert's rules the whole time, you take up items, vote, and the meeting's over. But when you have hearings, the meeting turns into a different animal. You become the judge at that point.
Okay.
I've laid out what we use as procedure for other appeals boards and similar hearing boards where the staff makes a presentation, and then the complainants will make a presentation. Then the official who's being complained upon will make a presentation. You will open up the floor for public hearing because that is required by law.
Okay.
And after that, you will be able to question anyone that you feel like you need to question. When you're finished questioning, you close the public hearing, you close the information portion of the hearing, and then you deliberate. Normally, Robert's rules require that you make a motion before you deliberate, but you don't necessarily have to do that when you're a hearing body. You might want to discuss for a little bit of time before you actually make a motion to do something. You're a little different in that way, but the procedures and bylaws kind of lay that out for you. You can change that. Those are just guidelines and rules that we use for building a street standard, Board of Appeals, BZA, those kind of things. But that's how it would work.
On evidentiary issues, do we have, I'm sorry, I just don't have what you apparently sent because I try to be diligent and look for things that come over, but
Totally understand.
I didn't see it. Do we have some guidance on what evidentiary rules we're to follow?
Well, there aren't really.
Okay.
And we aren't under the UAPA, and we can't be because we're a different type of government.
Okay.
The way it's laid out, I'll just kind of read it to you. For a hearing, it would you would have an explanation of why the application is before you, and that's going to be presented either by myself or an outside attorney that the city hires to do that work. You, as chair, would place time limits on presentations if you wanted to, and how the proof would come before you. There would be a staff introduction of what the issue is. Then the official would have their time to present to you. If you want to put time limits on that, you can. Again, the complainants would also have time to present to you what they want to present. You have a couple of hearings that are going to have to be scheduled for, in particular. Some have one complainant and some have multiple, so you'll have to kind of figure out how you want to lay that out. Then at that point, you can put time frames and time limits on the public comments if you want 1 minute, 2 minutes. And at that point, you would deliberate, and you would use what's been presented to you against the ethics ordinance and decide for yourselves what you think, if anything, has been violated, and then what recommendations you might have for the board.
Now, the ethics ordinance is part of our notebook, is that correct?
It is.
Okay.
It is. If at any point you feel that there might need to be more investigation, you have that right as well to say, we need to defer this and get more information and say what that might be.
Thank you.
Give this one to Vonna. Yeah. Oh, it's passed around. Okay, got it. I've got one, thank you.
And Juanita, do you need one?
No, sir.
And Jerry, you have one.
Thank you.
Thank you very much.
So maybe before we finish up with the bylaws and look into that, you might want to go ahead and name your vice chair.
Shauna, before we do that, we do need a second for the chair nomination. We just had Jerry do the nomination. So
Okay.
we just need a second.
What had it?
I thought Juanita did that.
Oh, I'm sorry, I didn't hear that then.
Juanita
You're good. I just didn't hear it then.
Did we vote?
And we voted.
And we voted.
We vote.
You're good then. Sorry.
Are we going to
So now
vice
we
chair?
need to nominate a vice chair.
Yes.
I'll nominate Juanita Pat.
Second.
And I move that she be selected by acclamation.
Okay.
Thank you.
Okay, this is good. So on page 4, I see where it lays out the procedure that we're supposed to follow. So that's very good.
Oh, he said by acclamation because it was unanimous.
Yeah, I didn't, because we missed that. We missed it on the first part. I didn't know if we need to do that for the chair part. Because I was getting ready to say that by acclamation, but,
Yeah.
okay.
I mean, there's only 4 of you, so.
Okay.
And I gather there will be a record kept of the proceeding with either a court reporter or some sort of recording?
Both. We'll have minute takers here as we normally do, but for hearing matters, we will have a court reporter word for word. And we'll have video.
Should we start into the bylaws and procedures? Is that where we're at? Because I have some questions.
If the chair is ready to move on to number 3, yes.
Yes, I am, if the rest of the members are.
My first question is section 3, paragraph 5, about we're authorized to hear appeals decisions of the city engineer or the director of engineering.
Oh, wait, I must, what page number is that?
Section 3.
Page 3.
Section 4. You're talking about section 4 meetings?
Oh, I see what you're saying, paragraph
Yeah,
5.
section 4. I said 3. I'm sorry.
Yeah, I need to take that out.
Okay, good. Because I thought that'd be a board of zoning appeal.
Okay, so number 5 is coming out.
Yes.
And show me again, Sean, what we're
Maybe I
doing.
can pull it up. Hold on. I just learned how to do this.
This
Yeah,
one.
there
There
it
we go.
is. It's section 5 right there.
Right there. We'll check section 5 out.
I think on my next question is in the hearing procedure. That very first paragraph, it says, within 60 days of receipt of the complaint, the commission shall conduct a formal public hearing in accordance with the requirements of due process. The commission is authorized to subpoena and swear witnesses. My question is, how is that going to happen?
The time frame, I know it's tight, and that's coming from the model rules that were approved by MTAS, and I think also provided to the state as the OK model rules. We have to hold a public hearing. We have to get to a point where you've met. That doesn't mean that at that point you can't defer it and say, I've heard the public's comments, I've heard the complaints, I need more information. I would like to have subpoenaed these following people. I would like more investigation or more time. We just have to have that public hearing in those first 60 days.
Well, for a complaint to be a complaint, they have to file it with the city recorder.
Right.
Does that initiate that 60 days?
That's what starts the 60 days.
That's what starts the 60 days.
Yes.
So, I mean, it conceivably could be like a week before we may even know about it.
Well, the code also says that once the city recorder gets a complaint, it must be immediately forwarded to the chair. We'll send it to the whole commission so everyone
Sure.
has it, and to me. So immediate, we've kind of determined to mean same day.
And that's fine, but should that, well,
Yeah, it does say immediate. Let me see where it says that. It may not say it in this section. It says it in the municipal code, because that's what governs us, and it doesn't really govern you. So it's not part of this, but it has to immediately be forwarded to you.
can we change that to 90 days? Or should we not do that? I mean, I
So,
don't know. It just seems like a tight window to me.
It really does. I don't disagree. I can do some research on whether or not we can change it to 90 days. I don't know if it'll affect the ones we have in the pipeline right now,
Right.
because we already have those kind of scheduled. But we can look into changing it to 90 days. I think that would probably help everyone. But yeah, and you guys would recommend that change, but ultimately the board has to approve the municipal code changes.
Sure.
You know that.
Well, I don't know that if, Shauna, if you want a formal motion on our part to say, check out 90 days, it's fine with me for you, just
I'm
bring
fine,
it back
and I'll
at
bring it
another
back to-
meeting,
yeah,
okay?
And I will tell you.
Well, and if we find out that we can't do that and we're gonna have a really tight window, can we set ahead dates that we're all available and we cannot meet? If there's not a public hearing, is that an appropriate thing that we can do?
Like just set days out in the,
That we're gonna meet?
yeah. Yeah, we can do that. I mean, a lot of commissions do have like standing meetings, like they meet every, every other month or every month on this time, on this day of the week. We could do that and it just be set. That could be helpful. Again, when we first met a month ago, I said, this commission isn't really that active. And I shouldn't have said that because, I think I jinxed it.
Now we are.
And here we are.
Well, let's see if we can do the 90 days and then go from there.
Yeah.
But what I understand you saying, Shauna, is that this time frame is actually in a city ordinance.
It is. It's in it, and we can't change it for the ones that have been filed already.
That's-
It would be a future change, but
Right.
since we're going through the procedures,
Yeah, that's fine, but you're right. We need to comply with what's here. now.
exactly,
right.
exactly.
Right, we don't have a choice right now.
Right.
My next question is in the next paragraph, paragraph 2, section C. It says, after the staff introduction, and this is in the presentation and public hearing, after the staff introduction, the complainant shall present his or her case and shall provide 1, 2, and 3. My question there is the complainant. Are these limited to those who have filed with the city recorder?
Yes.
Okay, because I didn't know if somebody could just show up at the public hearing, I want to complain or not.
They can speak during public comment, because we do have to have a public hearing. We do have to open it up to the public to speak. But they do not get the ability to present a case and lay out their facts. They can just, like any other item on an agenda at a board meeting, they can come in and speak for a minute to 2 minutes, however long the chair wants to give them.
Okay, good. Down in paragraph E,
Jerry, before you go to E,
Sure.
what is the difference in D between the complainant and the official? So in other words, C says that the complainant will present their case with their name, the statement of the alleged violation, any witness in support. Then it says the official shall then present his or her case.
That would be the elected official, that's the elected official of whom the complainant is complaining about.
let's add elected in there.
Well, it could be also an appointed official.
Okay.
So you get this
Okay.
body would hear historic zoning complaints and planning, so not elected all the time.
So
So section C is about those making the complaint, and D is about
yeah,
the person they're complaining about.
Right.
Yeah.
And we don't have a whole lot of rules on how they present that case to you. We kind of feel like that's left up to them. We don't require them to make any sort of statement or anything like that. They just get to tell you what it is they want to tell you.
that's fine.
It is in paragraph C, is it the section that we should consider a time limit on the public hearing aspect?
No.
Okay.
Now, not for the this isn't a public hearing. This is the person who's actually
Making the
bringing the case
presentation.
to you.
I'm sorry.
The chair can say, I'm going to limit each side to 15 minutes. I'm going to limit each side to 30 minutes. That the chair can make that call.
Okay.
Or you could just not have any time limits and let it happen the way it happens.
So down in paragraph 6, where the public hearing is occur, paragraph E, did I say 6? I meant E.
I was looking for 6. I was like,
I'm sorry, Shauna. In paragraph E, where the public hearing is at, that's where those who have filed with the city recorder would have been up in paragraph C.
Right. So these.
But anyone
people-
else would be in the public hearing aspect, and that's where the time limit could be set.
Right. Right. And these
Like
could be people in support of
2
the
minutes
official
or something.
or in support of the complaints. Or just people who want you to think about something, anything that they might want to say.
Should we write a time frame in here for each person?
You know, sometimes I'm going to kind of leave it up to you as a board. I know with our board mayor and alderman, if there aren't that many people standing up to speak, he doesn't normally limit time. But if you see that there's 100, you might want to say, I'm limiting everybody to a certain amount of time. So I kind of think maybe you should do it at the beginning of each hearing, but I think it should be kind of a decision you make at each meeting.
Okay,
That would be my advice on it.
just leave it to the chair.
Well, and what my thinking is, I would confer with all of you, and maybe we'd make the decision as a group. I would announce the decision.
Yeah,
So if we've got 3 or 4 folks that want to speak, then I don't know that we'd have a problem. If we've got, as Shauna said, 100, then we would need to do
Yeah.
something to make a limitation.
that'd be the general guy.
And I think that's the thing to do.
Yeah.
We'd confer with one another and make that decision. Shauna, I've got an initial question. As I look at the notebook that you gave me, I went to this website, which is http://www.tn.gov. It no longer works.
Okay.
Or at least I don't think it works. So, but when you go through the ordinance requirements after that page, is there going to be somebody that screens the complaints that are filed with the city to determine on the front end that the complaint, in fact, is a colorable claim that would violate an ordinance of the city?
Well, technically, that's supposed to be the chair's role, but up until now, we didn't have one. So after this meeting, maybe my office and you, we can kind of talk through that. As city attorney, I don't feel like I can look at someone's complaint and say it shouldn't see the light of day by the Ethics Commission. The Ethics Commission needs to decide that. I don't want to prejudge anything. That would be your role.
I mean, the ordinance of the city specifies conduct that clearly violates the ethics that the elected or appointed officials are supposed to follow.
That's right.
So if the alleged conduct doesn't fall within the 4 corners of any of these prohibitions, and there's no colorable way it could, then the issue is how do you screen that out on the front end?
And let me pull up for you the municipal code so you can see this.
Okay, because I'm working off of this page in the book, and it says ordinance requirements. And here there are 7 bullet points. And then it goes beyond that, and it discusses each bullet point in the subsequent pages.
Is that in section 3?
It's an untabbed number,
It's the one that has this.
but it begins with this page called ordinance requirements.
There you go, that page right there.
Mm-hmm.
And I've pulled up for you the Ethics Commission Municipal Code section
Yeah,
that says that the Ethics Commission, in the event the Ethics Commission makes an initial determination that a complaint is technically deficient or incomplete, the commission, because it has to be you guys, it can't be me, shall submit a list of deficiencies to the complainant and offer the complainant the opportunity to correct those deficiencies within 7 days
Now,
prior to the investigatory review.
is that in our notebook?
This is in the municipal code. It should have been in
No,
your notebook, but if it's not,
is it in the notebook?
it should be, yes. If it's not, we can make sure we print off all of that. I didn't bring the notebook with me, so I can't
Well-
point to you the tab.
I think it is,
It should be toward the back.
It is. It's the next to the last tab,
All right,
and it's.
okay, all right, I see now what you're talking about. Okay, so,
And this would be section 2-310.
okay, complaints, all right, very
And if you
good.
look at paragraph 4.
All right, so it says, any person may file a complaint alleging violation of the provisions of this chapter with the city recorder, who shall immediately deliver the complaint to the city attorney and to the chairman of the commission or their designee. And then forward a copy by registered mail to the official against whom the complaint was filed. Complaint must be based on personal knowledge. That's number one. 2, set forth the facts that would be admissible in evidence. And 3, show affirmatively that the complainant is competent to testify to the matter stated. Attached documents. Then it says, must be filed within 30 days of the date of the alleged violation, or unless it's concealed or non-disclosed, it would be within 6 months of when it should have been discovered. And then it says, in the event the Ethics Commission makes an initial determination that it's technically deficient or incomplete. So technically deficient would mean, 1, it's not made on personal knowledge, or 2, it doesn't allege any facts, or it doesn't show in its face that the complainant is competent. Would those be, is that what you would characterize as technical deficiencies?
That's how I would also say yes.
All right, or, and then I don't know, when you say incomplete, I'm not,
Maybe that's a situation where they say that there's documents attached and then there's not, or they needed to have documentation and then there's not.
okay. Then it says, commission shall submit a list of the deficiencies to the complainant, offer the complainant opportunity to correct the deficiencies within 7 days. Prior to the commission's investigatory review. So are we to conduct the investigatory review? Who is to do that?
If you wanted to, you have the authority to. The code says that you can conduct your own investigation. I am working to hire outside counsel to do the presentation to you and to do any investigations that might be necessary.
All right, well, let me say that would be difficult. I don't see how we can serve as a hearing body and also an investigatory body, because that makes us witnesses.
I agree with you.
Okay.
I agree with you.
So I don't think we can do that.
I agree with you. Yes, I agree with you. I think we should do all of that work, because otherwise you're doing it individually as well, and you're not doing it as a collective body. So that, to me, that also feels weird with open meetings.
And we can't be witnesses and be
True.
a member of the hearing panel either. Then it says that the official may file a reply. So there's no reply required.
No reply required.
Okay, so it's strictly discretionary as to whether they will reply. But if they do reply, then it's got to be based on personal knowledge, set forth facts that are admissible, and show affirmatively that they are competent to testify. And attach documents. Okay. And then this is where Jerry was talking about, within 60 days then of receipt, we've got to have a formal public hearing. So that's, as I understand now, what you were saying, that's a really short
It's
window.
tight.
That is very tight.
I just,
Yeah,
It is very,
I
very
look at it
tight.
and I think, how is all this gonna happen in 60 days?
But that doesn't necessarily mean you have to make a decision at that meeting. It just means that that is the public's time to address you on their thoughts on the issue and to allow the complainant and the official to address you. You might want more information after that meeting.
but I go back to the initial concern. When the complaint is filed, this seems to indicate that the commission is going to at least screen it to see if there is a colorable claim of violation of the code of ethics.
Right, and the way that I think that would work is if you felt like, or if any of you felt like it, you could ask for a meeting to be held to discuss that, because you can't do it on your own.
Right.
You have to do it in front of the public. We have to have notice, so
Right.
you'd have to do it together to talk about that, and it would have to be noticed on an agenda. But you can do that if one of you feels that there might be deficient.
But this is not a function of the staff. That's the
Right.
point. It's got to be done by us.
It has to be done by you.
So if we read it and we don't think that this complies with what's required, we call our chair.
No, you would want to call me,
Okay.
and I can facilitate the meeting. You can't talk to each other
Right.
outside of this room about anything that you're going to talk about.
Okay, we call you.
Call me.
That gets at what I was gonna say is, the only way we can determine that it's deficient is to have a meeting.
That's right. And maybe when you have it within those 60 days, even at that moment, at that meeting, you could say, I've listened to the complaint, I've listened to the officials, I've listened to the public comment, and now I still feel that it's not complete. If that's what you feel, you would still need to write, as a board, what those deficiencies are and give them 7 days to fix it, even after a public hearing. That is an option that you could do.
Well, in our meeting, our bylaws and procedures, should there be a section I'll say at the first part of meetings, section 4, that as part of our procedure, we would have an initial meeting to determine if the complaint is,
Colorable.
yeah.
That sounds like,
It doesn't say we're gonna do that in the procedures.
but what you're saying makes sense, because as I understand what you're saying, if we get a complaint, we look at a complaint and we apply the allegations of the complaint against the standards in the ordinance, and we don't find there to be an allegation that would violate a standard if proved, then we shouldn't go any
We
further.
don't have to go any further.
That
We
would-
shouldn't go any further.
No, that would end it.
Right. And should that not be a,
I mean, it puts everybody to a lot of trouble, but you could do it at the beginning of any hearing.
could you just insert something like that, Shauna, in section 5, where you're gonna take the bozo stuff out, I call it? That the commission will have an initial meeting to determine, you see what we're saying?
To determine if the
It would be to determine the adequacy of the allegations,
Yeah,
which if proved, would constitute a violation of the municipal code.
So we can do that. If we would have to have a hearing pretty quickly after a complaint's been filed, because we still have that 60-day deadline that we're pushing up against. If you say it's insufficient or inadequate, or there's technical deficiencies, we have to give the complainants 7 days to fix those deficiencies. We write them up, and then they have 7 days. But that's what our process says. So if we may have to just work really, really fast to meet all those deadlines.
if they change it in any way, would that not restart the clock?
That was my question.
We should say that it does. I think we should say that we should be clear that it does. Because sometimes, in particular with some of the ones we're talking about right now, there are a lot of people who want to come talk to you. And so changing dates a lot is impacting people who are waiting to get in front of you.
Well, my feeling is that if the complaint changes, you restart the clock. I mean, that's just, I don't know if that's legally justifiable.
If we review a complaint and conclude that on its face, if proved, it doesn't constitute a violation of the municipal code, then we'd have to notify the complainant of the deficiencies and give them 7 days to cure. It would have to restart the clock because nothing else
That's
works.
what I'm saying.
I'm
But
comfortable with that.
On the other side of that, if we review it and say, yeah, this is a legitimate complaint, the clock has already started.
That's right.
That's right. That's right. So you want an initial discussion amongst yourselves after a complaint's been filed as a policy?
As a what?
As a policy. So you do it every time?
Well, if you don't do that, then what you're going to do is you'll set the matter for hearing. You'll have an initial discussion. If the commission concludes there's no colorable claim that's alleged, then everybody's wasted their time.
I'm comfortable with that.
I mean-
If you're willing to put that time in, I'm comfortable with that.
I don't think we have any choice.
So we have a meeting scheduled for the 15th, June 15th. We're going to have to schedule something in between that. So we can talk about that at the end of the meeting if you want. If you want to keep going through the bylaws and the procedure, get through that, and we can pick a date.
And what time on the 15th do we have a meeting?
It's at 5 o'clock.
5 o'clock.
That's our hearing.
That you're hearing, that you may or may not have, depending on what you do at your next meeting.
Well, it's either have another meeting and consider the complaint's adequacy, or consider it on the 15th with the understanding that if the complaint doesn't meet the standard, then it would not have been a very fruitful meeting.
I'm very comfortable with this.
But I think, Jerry, you're right. That to me is the way we need to proceed. Ivana?
I agree.
Juanita, you agree?
Yes. I think we have to.
If you want to keep going through the procedure, we can do that, and I can make all these changes, so when we make this next meeting, that will be also your initial discussion amongst yourselves about the complaints. We can approve the bylaws at that point. We don't have to approve them tonight. I can make all the changes that you want.
I'm fine with that.
Okay. And if you have any other changes between now and then that you didn't discuss tonight, you can just email them to me.
So really what we're talking about is creating a new section that calls pre-hearing determination.
Yeah,
That's what you're talking about.
exactly.
Well, where it says, in section 4, item 6B3, the commission may meet to make an initial determination that the complaint is technically deficient or incomplete. That could just be reworded to say we will meet, to make sure that it,
That it's not technically deficient or
yes,
incomplete.
that it is not technically deficient. So instead of may, it is will.
Yeah, and I could even put like a little title on it to call it pre-hearing determination and then set that out.
Can those be done by Zoom?
No. No, it cannot.
And you have to publish an agenda.
We have to publish an agenda.
So how much, let's think about time. Once you get a complaint and it comes in and it's sent to the official, when will it be sent to us? Immediately?
Yes, I think we've sent all of them to you within 24 hours of getting it. So
Okay.
sometimes we get them at night, so we don't send them to you till the next morning, but within 24 hours. And then at that point, because of the way you're asking for this, at that point, we would then set an initial meeting.
I think so.
The pre-hearing meeting. As soon as we get it, we can do that.
That's how it's got to work.
And I'm comfortable with that. So how quickly does it run in the newspaper?
Wednesdays, Thursdays.
Yeah, so we have to have it on a Wednesday. We have to have it all together on a Wednesday to run in the Thursday paper to notice it. And usually we like to give about 3 days notice. So that's kind of what we're working on, to have it for the next day. So if we published it on Thursday, we could probably have it Tuesday or Wednesday of the next week.
And do those meetings all need to occur at night?
No, they can occur whenever you want them to. Historically, though, when it's a public hearing, we like to have them after 5 because that's when the public gets off work and they can come and talk to you. Most people can't take off time to do that. But your initial determination meeting can be whenever you want it to be. You can make that call.
Well, once we receive it, we'll each review it, and then we'll have our meeting and discuss it. Let me ask the members, do any of you have a preference for a day of the week and a time of day that would be best for you? So that Ms. Billingsley will know basically this works for everyone, unless you're out of town, of course,
For that initial meeting?
for that initial meeting, right? And I don't anticipate the initial meeting will be long, because that's really a question of looking at the allegations, comparing them to the ordinance.
To the ordinance.
Make a determination as to whether the allegations at least state a colorable claim under the ordinance, and if so, move on. If not, then we notify the complainant of the deficiencies and we move on. So it should not be a long meeting. The question is whether we all have a day of the week and a time of day which would be the best for all of us that Ms. Billingsley can sort of count on.
I do not.
I'm thinking early morning.
And early morning
With
is fine
coffee.
as well. We do have early morning meetings with our developers from time to time. I do want to clarify, and I had a sidebar with the city administrator. When you have this initial meeting, this will be based solely on what has been provided to you. There will be no extra
Right.
facts.
That-
The complainant
Exactly.
will not talk, the
That's right.
official will not talk. It's solely based on what is in writing to you and nothing else.
That's why I don't think it will be a long process.
Right.
We will have read it, we will have compared it to the provisions of the municipal code. We'll come to the meeting, we'll discuss it, and we'll make a decision.
11 o'clock.
Yeah, we could do an early morning meeting just for that meeting.
You can do
I'm
it at
fine.
any time.
Yeah.
I mean, we do have to have staff there. And we'll probably televise it, but that's not a big
We could
deal.
do like 11 o'clock.
Yeah, or 9.
Those aren't early times. What's early to you?
7.
Let me ask this.
7.
Most of us will have, during the lunch hour at noon, most of us would be free, I would think. Juanita?
My schedule is just kind of flexible.
Is it?
It's just kind of whenever I have a closing or whatever, so it's really kind of hard to predict. But I try to, but pretty much I'm open most of the times.
Okay.
So
If a
a
set
noon
meets
or
Thursday.
something.
Noon, I can always
Midday.
stop what I'm doing at noon and come over here to City Hall and conduct this business, because I don't envision this to be protracted.
Okay.
Jerry, how does noon look for you?
Long as you-
Juanita?
yeah, it's fine, as long as you let me know ahead of time, because I'll work from Franklin instead of Brentwood. Yeah.
Okay, so Ms. Billingsley, it looks like to me noon would be a time that would be convenient for most of the members of the commission on any given day. And I frankly don't have a preference on what day you want to do it. My thinking is if we agree on noon, and then you just back out the number of days, you know how much time you've got to give notice and publish notice and do all those things, and you just tell us when to be here.
Any day is better. Is just just so long as you've got enough time.
That's right.
You'll have at least 3 to 5 days notice, because I mean we have to publish it.
And once she tells us, we'll immediately respond and say, okay, or if we've got a conflict, we'll immediately respond and let you know, and you'll pick another day.
That's right.
That works good. So it'll be noon on any given day, and then we'll come and do our business. Excellent.
And that's gonna have to be going forward, not the ones we have presently, correct?
No, we can absolutely do that. So my thought is, as soon as we can get a meeting scheduled for the complaints that we have right now, we can go ahead and have that meeting. We have 4 complaints, so we can do all 4 on one meeting, or if you prefer, we can do one at a time. It'll be up to you.
Well, you're saying there are 4 complaints that are pending?
I guess I should say it this way. There are 55 complaints against one alderman. 59? Okay, 59 complaints against one alderman, 1 complaint against one alderman, and 2 complaints against our mayor, and 2 complaints against another alderman. So the way
So
because
you've got
they're
4 officials.
4 officials,
Okay. Wow.
but 2 complaints
Right, I got it.
are connected. 2 officials are connected, and the other 2 are connected. So it's possible that we could do a meeting with one set, and then the next week a meeting with the other set, or we can do all at the same time.
But we're right now operating under a 60-day gun.
We are.
So this won't be a short meeting.
Right.
We just need to bite the bullet, schedule the meeting, and take it all up.
Okay,
And
I'm happy with that.
and consider all,
Already done for the 15th, isn't it?
Well, the 15th is the public hearing. So what we're trying to figure out is, do you think that the complaints, and again, out of the 59, they're all similar.
yeah.
Out of those 59 complaints, do you feel that there is any issues with the complaints? Do you think that they are sufficient to move forward or not?
We understand what we got to do. I don't think we have any choice, and I want to hear from the other members of the commission, but to me, we have no choice but to go ahead and now bite the bullet, take up all 4 of them, and make that initial determination, but it won't be quite as quick as I thought we would be.
I agree.
But I think in order to comply with the ordinance, we're going to have to do that. If you don't comply with the ordinance, then you get questions on writs of certiorari, on procedural issues that the city doesn't need to have to contend with.
I'm glad you're here.
I am too.
So am I.
All right, then let's set it. Let's go ahead and set the initial meeting for those complaints that have been filed. And
Angie, our city recorder, is saying the week of May 15th is the earliest we could do that.
Wednesday, May 15th.
And the rest of that week, or any time following that. So is there a day?
Wednesday's the 17th.
Oh, okay, Wednesday's the 17th.
Wednesday, the 17th.
But we can do it as early as the 15th. So just look at the week of the 15th
The week of the 15th
at noon.
at noon.
Can we do the 17th?
The 17th is fine with me.
It's what I need. At noon, I can be available. I
Sure.
cannot on the 15th or 16th.
Yeah.
So 17th?
The 17th.
So we're looking at meeting on Wednesday, the 17th at noon. Now, is that to look at the complaints we already have?
Yes.
Yes.
And whether or not you feel like they are sufficient to move forward.
Are we canceling the 16th?
We are not. June 16th?
It's June.
Oh, June 15th. No, we're not.
Oh, well, I'm sorry, I'm looking at May.
Well, so May 17th for your pre-hearing.
Okay,
We'll call it the pre-hearing, as Judge Martin said. And we will keep
the
the
15th.
15th. And you will make a decision on May 17th, how we move forward.
I'm fine with that. At noon that day?
Yes.
Very well. Then, Ms. Patton, that work for you?
That works,
And Ms. Vaughn?
that works for me.
Okay.
Because I have a 10 o'clock, well, I have a 9 o'clock that same one, so I just work there.
Then-
That's fine.
Then,
If I see anything different, I'll let you know.
Right.
But right now, I know everything's fine.
don't even think about it.
Don't even think about it, just change my other one.
And then clarify, let's clarify our
June,
June 15th at 5 is the hearing date that we've set so far. Your decision on May 17th might or might not change that.
thank you.
And that is only for the 59 that we have scheduled so far. That's not for anything else so far.
We don't have a meeting set on May 16th.
We do not.
And what time do we have that hearing scheduled?
On the 15th of June I just asked Ms. Billingsley, she said it's 5 PM. Ms. Billingsley, when do you think you'll be able then to get the materials to us so we can review them in advance of the 17th?
I can get everything to you tomorrow. I mean, they're already together, so I can put the packet together. We can get an agenda set up inside Civic Clerk, and I can load them up there. We will help you find that, but I will email each of you, and if you would prefer, I can print them all out.
I like paper.
I can do that.
I like to write on it, make notes
Yep.
on it.
We can do that.
So
I can do all of that.
I prefer paper.
Yep. All of you seem to really like paper, so yep, we can do
You
that.
can email it.
You can
You can email it to me. and
Do
I'll
what?
print
Okay.
it out.
Like,
I'll
You
do
like it
all
okay?
of the things, and
That's good.
and
Thank you.
we'll get you prepared.
Okay.
And so I can get all that to you tomorrow. And then I can make the changes that you want for the bylaws, and I will add that to the agenda as the first item so that we can
That's good.
pass that, and you guys will know what you're working under, and then move forward. But I'll send those changes to you as well, so if you have any other changes, we'll talk about
And
it.
remember, for whatever reason, I didn't receive the email, so I'll need to see the minutes from March 23rd. Oh, and anything else you want me to look at
Yes.
that was sent that I don't recall seeing.
We'll get it all to you in paper.
Thank you. All right. Do we have any other business tonight that, yeah,
I have some more questions about procedure.
Okay?
I'm looking at page 4. The very last sentence, a statement by the public member believes alleged violations occurred, and if there was a violation. Can a public member also stand up and say it didn't occur?
Yes.
Should we say that a public member believes alleged violations occurred or didn't occur?
Yep, I can change that.
Okay. Page 5. Up generally in paragraph H and I in cross-examination. It's my understanding that, basically, people are not going to be allowed to cross-examine somebody else.
They're not, right.
This is all must go through the chair. Somehow, that paragraph I, any member of the commission may directly question the staff, the complainant, official, public members who spoke during the public hearing, or witnesses appearing before the commission at the time during the testimony. Now, I take this to mean that the public hearing is over with and that one of us could ask someone who spoke a question. Is that what it's intended
So
to be?
it's sort of like a two-step process, the way we handle generally our hearings of this nature. The public, the complainant, the city, the official, whoever else, gets to present everything that they want to present to you at the beginning of the meeting. You can then ask questions of anyone that's presented to you during that night. But at some point, everything shuts off and the communication and the discussion is only between you. And no one from the public can stand back up and say anything. No one can give you any new information. The only way to change that is if one of you said, I actually have another question, I've just now thought of it, and I would like to ask someone this question. Chair, may I ask this question? The chair gets to decide if you're going to get to ask the question or not, or if you're going to continue deliberating as a board. But there's no more discussion with anyone past the dais. It's just you.
Well, somebody can make a statement during the public hearing that you would like to ask a question about. And that's the time to do that,
That's the time to do it.
not during the public hearing.
You can either do it during the public hearing or when the public hearing has closed.
You can ask the chair
Usually the
for-
chair will
okay.
say, that's all the public hearings, that's all the public comment. Does anyone from the commission have any questions of anyone who has spoken? And that's when you would do that. Once that's over, now it's yours. You deliberate. You should have all the information you need.
Fine, thanks. Down in section M, the word censor appears. What are the bounds of that word for this commission?
So the way I understand this, the municipal code and the charter only allow one board to censure, and that's the board, mayor, and alderman. So the way I see this is that you would recommend censure, and the board would censure if it so chooses to do so with that recommendation. I don't really see this board doing that. There are lots of things that can happen to elected and appointed officials. I just don't know how much authority this board has to actually make that happen. I think it's more of I've heard it, I see the violations, I don't see the violations, and here's our recommendation.
Thank you. The next part that I have a question about is in the post-hearing, section 1. Judicial review of the last sentence shall be based upon the record. No party shall be entitled to a de novo appeal. My question is, can this be established by procedure, by our procedures?
Well, I mean,
Because
this
that's
is,
like a court.
yeah, this is state law. So that's what Mr. Martin was saying earlier, that whatever decision you make, it would come, if someone's not happy with the decision that you make or the comments that you make, it would be a writ of cert coming out of this board. It wouldn't be, and when that happens, it's what this board did solely based on the record. And historically, and Judge Martin can maybe explain this better than I can, but even though we record it, the rules say that it's based on our actual written record and not the video. So they won't judges generally don't watch the video. We always produce it, but it's never watched. So it's just what's on the record.
So in an appeal situation, it's going to be on the record, basically.
Right.
Yeah, Jerry, the words de novo means anew. So, for example, if you bring a suit in the General Sessions Court of Williamson County and you're not happy with the result, you get a de novo appeal to circuit court. And if you do that, it's as if the proceeding in the General Sessions Court never happened. Here, it's different. The hearing before this board will result in a decision that's recorded, a written record, and the review is strictly based on what we do. And the circuit court reviews what we do to determine whether it has a factual basis.
Arbitrary, capricious are kind of like the main things that judges look at as to whether or not you were
Yeah.
arbitrary, capricious, or otherwise biased in your decision making.
On that point, there are a couple of places in here that specify that our decision must be written. If we announce it orally and it's then reduced to writing by the city, will that meet the standard?
I'm gonna say no, and we will write it up for you based on your. We would write it as an order of or recommendation of the Ethics Commission, and then the chair would sign it.
So we can deliver an oral ruling
Right,
that will then be reduced to writing
right,
and signed by the members of the commission
or just the chair.
or by me.
Yes.
Okay. Good questions. Very good questions.
That's all the questions I have.
And
I'll shut up.
And no, you.
Great question.
Very, very, very good question. And then Shauna, on M, the one that Mr. Sharber was just looking at on page 5, this all also gets to the pre-hearing procedure. You see, it says, after reviewing the complaint commission made by majority vote, determine that no specific substantial evidence from a credible source exists to support a reasonable belief that there's been a violation of the ethics code, or determine that there's no violation occurred and it may dismiss the complaint. See, that is almost, if not entirely, pre-hearing procedure.
Yes, and
So you may want to either eliminate it from M and move it into a new section on pre-hearing procedure, and then reword M to make it clear that after all of the evidence has been received, then the commission will make its decision and it'll be in writing and it's de novo.
I can do that. Now that you've determined that you want to always have the pre-hearing, the way it's written, a pre-hearing it's optional. So that's why you can dismiss it after the public hearing. But now that you're making the determination to always have initial hearings, then we'll move that up.
So M will be split up then.
It will be.
In the new version. Okay.
I think you did an incredible job with this initial set. I want you to feel that way. I mean, I read through them, obviously, and I like, Shauna put a lot of work into this. I know why at the last meeting she said, I don't have them ready yet. So thank you.
Well, I appreciate that. It's real world now, so.
With those modifications, then, do I have a motion to approve the bylaw and procedures?
So moved.
I'll second.
Very well.
I'll second it.
Thank you. Is everyone in agreement?
Yes.
Aye.
Show it to be unanimous. And then paragraph 4 of our agenda is to discuss a procedure for an Ethic Commission hearing. I think we've got that now, don't we, Shauna?
We do. I do want to hand out to you, and I won't go over it right now, but
So going forward, we're only going to have 4 members then of the commission. We will not have a 5th member.
not while we're in the midst of the active complaints. Once we move past that, we will bring a 5th member on, but right now is probably not the time to try to do that. So what I've handed you is a PowerPoint that I do for the elected and appointed officials, but I kind of want you to see it. I can send it to you if you want. You guys are really smart people, so I don't need to read all these PowerPoints to you, but it's how to use Robert's rules. As we talked through most of this meeting, a lot of what you're doing isn't going to be Robert's rules. Anytime you have these public hearings, they're going to be the rules we set out, which is different than Robert's rules. But Robert's rules are very odd. I don't know that people really, Jerry, you know Robert's rules, but otherwise it's kind of a complicated way to run a meeting meant to make it better and faster and more efficient. But I do think it's important to kind of know how Robert's rules work, how you would make motions and amendments, why agendas work, how you can change an agenda, the role of the chair. I think that's really important for you to understand that you guys can't talk to people outside of the dais, and you really shouldn't even talk to each other. Every comment that you make needs to be addressed to the chair. So you would ask the chair, may I ask Juanita a question? And then he makes the decision as to whether or not you do that. That's officially the way you're supposed to have a meeting run. If you have a question for someone outside of the dais, you should ask the chair if it's okay to ask that question. Again, not talking over each other is really important so that the minute taker can keep up with the words that we're saying. Anything that's not a real hearing, everything has to proceed by motion. So you can't really start talking about an item until one of you makes a motion to approve or disapprove of something. Then you can start talking about it. That's a little different when you're having actual hearings because you have to hear all the evidence first before you can actually take it up. Whoever makes the motion speaks first, and you have to vote for your motion.
You have to vote for your motion, but not in the affirmative.
So if you make a motion to approve, you have to vote to approve. If after deliberation you say, I don't really like that anymore, I don't want to vote to approve, you have to withdraw your motion. If you make the second, the only reason why you're making a second is that because you want to discuss it. You're not saying how you're going to vote. You can vote either way, but the person that makes the motion has to vote with your motion. You can change your mind, but you got to withdraw the motion.
Should the discussion start after there's a second?
Yes,
Okay, thank you.
but it's not detrimental because the point of a second is to say at least 2 people want to talk about it. If people start talking about it, then technically someone wanted to talk about it. But a lot of this is in here. I just want to make sure you know how to run a meeting. If you want to talk about this, if you want actual training on Robert's Rules, I'm happy to do it. We do have a code of conduct for board meetings. I can send that to you so you know what it says. It's how we expect our commissions and boards to act with each other and how we expect the public to act with each other and with you. So we do have decorum. You can make a motion to defer. If you make a motion to defer, that trumps all other motions on the floor. So if you're in the middle of a motion to approve, someone says, I'm not ready, I'd like to make a motion to defer, everything else stops, and we can only talk about that motion to defer, and we have to deal with that before we can move on. That kind of trips people up sometimes, but that's kind of how that works. If you make a motion to defer, it has to be to a date certain, or else it kills it. So that's important to know. Robert's Rules will tell you that you can make a motion to reconsider at a future meeting, but the city of Franklin passed a resolution years ago that said that a motion to reconsider has to happen at the same meeting that the item is on. Otherwise, the item keeps coming back and coming back and coming back for people who don't like the outcome. So, and you have to be a person who voted in the affirmative for that item to bring forth the motion to reconsider. You can't be on the losing side. And there's some frequently asked questions about quorum and abstention that might be helpful if you're interested. I think most of you know and have served on board, so Robert's Rules might be pretty common, but I just did want to bring that to you. I feel like we're crash coursing you guys because we have to. But if there's any questions about that, I'm happy to answer it.
No. The Robert's Rules of Order, I think, are going to play very little role in what we do.
I agree with you.
Virtually 99% of what we do will be to hear matters initially and then hear the proof later if we decide it should be heard. And that's more of a quasi-judicial function than it is under the Robert's Rules. I also think that as members of the commission, once we are informed that there's a complaint, we need to try to avoid discussing it with members of the public. Because when we come here, we need to have an open mind and be willing to hear both sides and make a decision strictly based on what's presented here. It's tempting when somebody would want to talk about an issue that comes before the city. But I think the best thing, as much as we can, is to say, I'm on the Ethics Commission and I really can't discuss that with you. So I would encourage, as much as we can do that, to avoid any kind of conversation.
And I might add, because I've actually used this before and it works. If somebody just voluntarily walks up to you, you can't stop that from happening, and they start talking. You can just look at them and say, look, I've been advised by legal counsel that I can't discuss this. And
Yeah, and that's the only way you can handle it. And you have to be courteous and polite, and you want to be courteous and polite, but you don't have to engage in conversation, and you can't necessarily stop it until you realize it's something that you will hear, and then you can politely interrupt. There's nothing in our rules that says that's what we should do, but I think that's the right thing to do.
Thank you.
well, it is the right thing to do, and it's also the moral thing to do, in being differentiating between right and wrong.
Yeah, and I have an AG opinion that I can provide to you that distinguishes between legislative action and quasi-judicial action, and when it's appropriate to be lobbied by the public and when it's not. And it's really informative, I think, especially in quasi-judicial roles. If you really should not be lobbied. No one should ever try to talk to you about anything. But if that happens, you do need to disclose it on the record at the meeting that someone did talk to you, and especially if it's something substantive, and the rest of the board needs to know it. Because if you come in knowing something that the rest of you don't, it puts you at a disadvantage and the rest of the commission at a disadvantage.
Is there any further business to come before the commission this evening? Ms. Billingsley, do you know of anything else that we need to talk about?
No, I think we have some dates scheduled, so we've
Then,
got some homework.
Then we'll entertain a motion to adjourn.
So moved.
Second.
I'll second it.
Ms. Patton seconds it. All in favor? Aye. Then we are adjourned. Thank you.